without permission of the other joint owners and no duty to account. Under U.S. copyright law, it's very similar, but it's also different. There is a duty to account, even though there's still freedom to operate. The trouble is, intellectual property rights are created independent of technology. So if my client is in a joint venture and has produced a piece of software with its partner, that's a single indivisible piece of technology covered by two very different intellectual property rights. And when they start exploiting the software, is there a duty to account under the portion of the software covered by copyright joint ownership versus freedom from accounting on the part covered by patent joint ownership? The situation gets worse if you go overseas. In this example, I picked probably our biggest trading partner, Japan, and the country in Europe from which our legal system was derived, which is the United Kingdom. And you might think that rules for joint ownership are probably pretty similar in those three countries, or you might think they're very different. Well, whichever position you take, you're going to be right to some extent and wrong to some extent. In particular, the United Kingdom and Japan have relatively similar rules for exploitation of a jointly owned patent, but they make a difference between self-exploitation and exploitation for others. In other words, use in your own business versus licensing. And they say that you don't need the permission of the other joint owners to use it in your own business. That's like the US, but you do need permission to license third parties. At least so I've been told by foreign counsel. Okay, so there's a difference between the US and the UK and Japan. If you look at copyright law, there's yet another twist. The UK rules for copyright law are different than the US in both respects. You need permission of the other joint owners. And Japan has a sort of very Japanese type solution. You need permission, but it can't be unreasonably withheld. Again, so I've been told. So if you have a client that is developing intellectual property rights, let's say the copyright is vested in a piece of software, as most of you know, it immediately vests in all countries around the world due to the Berne Convention. And if they're filing patents, they're probably going to be filing patents around the world as well. What you have is an inconsistent web of rights and obligations to each other from country to country. Let's now talk about enforcement. As I mentioned earlier, every joint owner in the US under a jointly owned US patent is an indispensable party. What that means is, if one joint owner files suit and another joint owner grants a license after the suit has been filed, that license will either limit that suit or kill the suit entirely, and it actually depends on whether that's a non-exclusive license, which will cut off damages and the possibility of an injunction going forward, but leave the cause of action for past damages in the past, versus an exclusive license, because in an exclusive license scenario, the exclusive licensee itself becomes an indispensable party. So one of the issues that comes up all the time where I practice law is in Silicon Valley, companies do not want to be perceived as litigious. And if you ask them to, if you have a joint ownership situation and you ask them to join, they'll say, well, I don't want to join the litigation voluntarily. I want you to involuntarily join me because I can't be perceived as litigious. But if you drag me in kicking and screaming, I can sell that to the public. You just have to be aware of that because the standard for involuntary joinder varies from district court to district court. In particular, some courts follow a very old Supreme Court case that doesn't require personal jurisdiction. Other district courts follow the rules of civil procedure, which do. Okay, the last group of slides here. I've got 4 more slides. I'm going to run through this group. What can you do about joint ownership? I suggest you avoid it whenever possible. If you do have to have it, think through all the issues, contractually allocate all the rights and responsibilities, and leave nothing to chance. But if you can do something else about it, here are 3 possibilities for what you can do. Number 1, this is a blanket allocation of all IP rights that arise during the course of the relationship. Anything that arises goes to one party, typically the party that's putting in more money, or otherwise has dominant IP, or has significant leverage in the deal. This is a great solution. That party will then grant a combination of exclusive and or non-exclusive licenses to the other party, to the joint venture, to enable that party's use. The most important thing for you as attorneys is to get involved early in this kind of deal. Because I can guarantee you that when your business folks have been selling the deal to the other side as a partnership or a collaboration, it's going to be very hard for you as the attorney to come in and say, well, my client should own everything. You have to slant the deal as a development deal. I'm going to ask you to develop this for me. I'll pay you a little bit for it, but if you're doing it for me, I should own all the IP rights. This is a very clean solution. It's very useful if you have multiple parties, more than 3 or more, and also where you have long-term development, where there's a base, an improvement, another improvement, one. The second alternative is a variation on number one. It's the exact same solution, except you're doing allocation of ownership of IP rights on a case-by-case basis. So as a particular module of technology gets developed and the IP rights come into existence, you will allocate ownership of that particular chunk to one party or another, for example, based on who has the dominant background IP or what that IP is predominantly useful for, what field of use. And then you use a combination of licenses to the other party to get use of things. The third possibility is to have all the IP rights owned by a separate entity. This is particularly useful if you have an equity or entity-based joint venture where you've already got the structure and you can put all the IP rights in the entity, which can then grant licenses to the parties as well as to the rest of the world. I think I am probably about of time. Oh, 5 minutes left. Okay, trying to hustle because I don't want to keep my other speakers out of time. Does anybody have any questions for me? I apologize for going so fast, but it's a pretty compressed schedule, so I wanted to move it along.
Yeah, I have a question for you.
Yes.